This is, I don't remember how many years we've been doing this now, but it keeps getting bigger and more influential. This celebration of Constitution Day, which of course is not actually today, the 14th, but on Tuesday, the 17th of September. That's the day that the secret convention of our nation's founders, working in Philadelphia through the hot summer of 1787, concluded their work and thought it was good and sent it out to the American people for their consideration and deliberation and hopefully ratification. That was an amazing thing in human history, where a government was established by, as they say in the Federalist Papers, number one, reflection and choice and not force or accident. And here we are 2 centuries and a quarter later, still with a written constitution. One of the things we've been exploring over years past is how much of that written constitution remains active or has been dispensed with, not by the amendment process, by wise men in robes who think they know better. But we have seen some amazing trends and victories in restoring constitutional government in this country over the last decade or so. The revival of the doctrine of originalism, that what the Constitution says remains binding until it gets changed by the process that the Constitution sets out for change. What a novel idea. And of course, the litigation work we do at the Center for Constitutional Jurisprudence is just a subset of the work that the Claremont Institute does. The mission of the Claremont Institute is to restore the principles of the American founding to their rightful and preeminent authority in our national life. And, I was at a meeting in New York City a while back, and somebody that was in on the meeting that didn't know fully what we did came out of it and says, "You guys really think you can change the world, don't you?" And I said, yeah, great ideas can change the world. And among the best ideas ever set down by pen, by human hands in human history, were those in 1776 and 1787. And so what ails us today is not because we haven't progressed away from those things far enough, but because we've forgotten the wisdom, the practical as well as theoretical wisdom of our nation's founders. And the more we can get back to recovering and understanding that wisdom, the more likely we are to be able to confront what ails us in our society today. So that's why we do what we do, and one of the reasons why we hold this conference is to help arm you to help us in the effort, and to go out better armed with the arguments of what constitutional government looks like and proceed. So we have today, in addition to what's now become an annual award of our Reagan Jurisprudence Award, and I'll talk more about that at lunch today, our recipient, Judge David Sentel, we have 3 fabulous panels dealing with some rather controversial, contentious issues that are at the top of the news. The first panel, and Carol Matheis, our good friend who's the head of the local Federalist Society chapter, is going to introduce the panel in a moment, dealing with the threat posed to our liberty by the current trend of multiculturalism. And you're going to see when that panel gets introduced, we've just got some stellar participants for that panel. But also with a particular focus on current litigation underway, dealing with the new racial spoils system being conducted by Harvard University. We'll then break for our luncheon program, which is going to be across the street and at the Bush Conference Center. When we come back from lunch, we've got 2 panels in the afternoon. One was some of the leading experts and strategists on the abortion litigation front. They're going to tell us what's happening with new abortion restrictions coming out of the states and new jurisprudential views flowing out of the Supreme Court. And then in the second panel of the afternoon, we're going to look at both the Supreme Court's last term and the upcoming term and talk about some tectonic shifts and trends that are going on at the Supreme Court right now. And then, of course, because it's Claremont and it's Saturday and we've held you inside all day, we're going to have a nice wine and cheese reception at the end, which is always the case. Now, I am delighted to let you know that the president of the Claremont Institute is now here and arrived, and he can do the more formal welcome, Ryan Williams.
I would say thank you, John, but I won't. For calling me out. My apologies, stuck in a little traffic on the way down from Claremont. Welcome, everyone. I'll keep this brief since you'll hear plenty of me on this panel. But it's always a pleasure to celebrate with all of you Constitution Day on a beautiful Saturday here in Orange County. It's hard to get too down or depressed about the state of the country when we can get 100 of you to come here and listen all day to these important topics. So it's really at the heart of what we do, talking about how to revive and save the Constitution and renew it. So thank you all for joining us, and it should be a wonderful day. Welcome.
Good morning. Thank you for joining us. This morning we are going to be speaking about, as Dr. Eastman said, Harvard's Perverse Affirmative Action and Multiculturalism. We'll run through a summary of the origins of educational affirmative action, how we got the legal monster of diversity, and the consequences of that development. We are honored today to have with us Professor Amy Wax, the Robert Mundheim Professor of Law at the University of Pennsylvania Law School, where she teaches remedies, conservative political and legal thought, social welfare law and policy, and the law of economics of work and family. She's a graduate of Yale College, Harvard Medical School, and Columbia Law School. And she is widely published in all the national media, in journals, law reviews. We're honored to have her. Next, we will have Ryan Williams, who just spoke to you. He's the president of the Claremont Institute and the publisher of the Claremont Review of Books. He, prior to becoming president in 2017, he occupied many posts with the Claremont Institute. He holds a BA in political science and economics from Hillsdale College and a Master of Arts in politics from the Claremont Graduate University. We are also honored to have Lee Cheng, who is an attorney and civil rights activist with a long history of achievement in business, law, and public policy. He is presently a partner and the chair of the corporate practice group at Mashoff Brennan, a leading intellectual property-focused law firm here in California and in Utah. So what we will do here today first is have Professor Wax address us. Each speaker will take approximately 15 minutes, and then we'll have a long period for Q&A afterwards. So if you'll join me in welcoming Professor Wax.
Well, thank you for having me here. I'm delighted to be here. I hope you can all hear me. So the goal of my presentation this morning is to provide an overview of affirmative action in higher education and to consider its past, present, and future implications, including for this infamous Harvard case. And of course, this is a huge charge to cover in 15 to 20 minutes, but I'll do my best. Now, I'm going to address primarily educational affirmative action, AA, I'll call it, for so-called non-Asian minorities, known as underrepresented minorities, and that's a euphemism, but it particularly refers to African Americans, although as we'll see, affirmative action has spread like kudzu to other groups as well. Now, it's useful, I think, to consider why AA in educational institutions exists at all. Why do we have this practice? It all starts with the academic achievement gap, primarily the gap between blacks and whites in tests of educational ability, knowledge, and skill. There's an achievement gap now for Hispanics as well, and I'll get to that by the by. We can spend a lot of time on the numbers, and a search of the internet will give many to you, but a few facts will suffice to lay out the situation. Black children on average, and even controlling for socioeconomic status, are almost a year behind whites and Asians, and sometimes more in basic skills and vocabulary and knowledge when entering kindergarten. And these gaps continue to exist and even widen as children move through school. The average black 17-year-old reads at the level of a white 13-year-old. And this has continued. Someone just sent me details from Seattle. Blacks on average in their school district are 4 years behind others. We have scores on the National Assessment of Educational Progress, a nationwide test that shows around 12% of black 4th and 8th grade boys rank as proficient in reading compared to 40% of white boys, and that's nothing to write home about. And finally, we have average scores on the college admission test, the so-called SAT. For blacks, 250 points or so behind those of whites, even further behind Asians. We can go on to some of the professional tests, LSATs, MCATs. The numbers there are even worse. And none of these numbers and disparities have really changed or improved in the past 50 years or so. Now, the disparities are even more pronounced on the so-called right tail of the distribution, people who have scores and grades good enough to get into the most competitive colleges. And the number of minorities with those scores has always been small. It continues to be so. But their ranking competitiveness relative to other groups has deteriorated because the competition has gotten worse and more people are trying to get in. So that's the background situation. Now, how has society responded to this? Going all the way back to the 60s and 70s, public and private actors began to practice racial affirmative action, not just in university admissions, but in other contexts, hiring, federal contracting, etc., to increase minority presence, because on a strict meritocratic selection system, there was hardly any. And how did they justify it? As a form of remediation or recompense to compensate for slavery and past discrimination. And of course, undeniably, those recompense was valid based on what historically happened. Now, there was faith that by practicing affirmative action, we would be able to catapult these victims of racism, forward and erase differences and bring them up to speed. But the courts recognized early on that affirmative action as remediation, like reparations, which is currently a topic of a debate, fits uneasily under the law, the Anglo-American law of remedies. And that is because the benefits that accrue to many individuals who get affirmative action, those benefits don't necessarily match the degree of discrimination that they have experienced, and the people who pay for those benefits are not necessarily guilty of discrimination, nor did they necessarily benefit from slavery. So the culprits and the victims are ill-matched, and that has always bothered the courts. As a result, the courts declared more than once that vague assertions or notions of societal discrimination generally cannot support race-conscious government-sponsored preferences, and that remedial AA is contrary to basic equality principles, which they identified as colorblind. But affirmative action in education survived anyway. That is because the doctrinal rationale for affirmative action underwent a sea change. In the 1978 Bakke case, which struck down a quota-based affirmative action program at the University of California Medical School, Justice William Powell wrote a separate concurring opinion, putting forward an idea that has become highly influential and indeed central to the practice of affirmative action in education today. He suggested that using race for admissions was justified and even as a compelling interest under the Constitution if the goal was to create a diverse student body. He said such diversity, whether in college or graduate schools or professional schools, would serve important pedagogical goals. It would broaden the ideas and the experience that students were exposed to, and he cited the Harvard Flexible Affirmative Action Program as exemplary. The diversity idea eventually became the key pillar of the court's educational affirmative action jurisprudence, and not surprisingly, of universities' rhetorical justification for the widespread use of it. It took a while to get going, but in key cases in the 2000s, and here I am talking about the Grutter and Gratz case from University of Michigan, the Fisher case from the University of Texas, the Supreme Court accepted and entrenched the diversity rationale as justifying the use of race in admissions for public universities. And in doing so, the court adopted two important principles for diversity-based affirmative action. First, schools could not use rigid quotas. They had to achieve diversity through individualized, flexible selection methods with race in the mix. Second, the selection had to be narrowly tailored to serve the compelling interest in racial diversities. That is, schools could not make any more use of race than absolutely necessary for that goal. And although these two tenets seem to place significant limits on university practices, in fact, they have proved essentially toothless. Why? First, in the crucial Michigan case, Grutter, diversity was simply assumed to be pedagogically valuable and thus compelling. Second, Justice O'Connor's opinion for the court stressed the need to defer to university officials and other educational experts on the benefits of diversity with little scrutiny of the actual evidence. And this earned her sneering contempt from Justice Scalia, who in his dissent said that educrats' supposed expertise was simply a cover for political opinions and preferences. This is a theme that he's harped on many times. And in fact, he was onto something. The court stated deference to the experts, educrats, administrators, and faculty, gave the green light to the growth and spread of affirmative action, and most crucially, to the growth of a woke bureaucracy of true believers dedicated to the goals of diversity, inclusion, and equity, and the absolute necessity and irreproachable virtue of AA programs. And these developments have made AA not just hard to challenge, and more on that in a moment, but virtually impossible to dislodge on the ground. And we see that in the 9 states that banned affirmative action, where the number of underrepresented minorities fell initially, but then it crept back up. Well, that's occurred as universities have become savvier and much more secretive about the facts, about their methods, and have engaged in endless doublespeak, if not outright deception, about what their admissions offices are actually doing. More ominously, affirmative action has become intertwined with a pervasive cultural shift of wider significance. And here we come to multiculturalism. As Charles Murray has so trenchantly described, a growing elite of college-educated people living lives increasingly isolated from the rest of society has learned at college that there is no higher good than diversity, and that affirmative action is necessary and virtuous. And of course, this is backed up by the mainstream media, by pundits, by intellectuals, by big business, by the entertainment industry. Today, embracing the priority of diversity betokens membership in the club of right-thinking and right-feeling people, that you are not part of the deplorables. The problem, of course, is that although diversity as a social goal may sound benign and even laudable, socially engineered diversity has real shortcomings and downsides and even dangers, and especially as practiced in higher education today. First, the diversity rationale for AA has given sweeping power to university bureaucrats and officials, virtually unlimited, and I've alluded to that. Despite all the lip service to narrow tailoring, right, there is no effort to really try and document and to show or gather evidence of the benefits of diversity. It's just kind of assumed. So it's become a fertile fudge factor, giving educats a free hand to advance their political goals. Secondly, AA, for diversity rather than recompense, is an inherently expansive doctrine. It allows for the potentially unlimited extension of affirmative action beyond blacks, the original beneficiary group, to others, and it does so in a perverse way. Underachieving groups are the ones that receive the preferences. Groups that do fine on their own don't get the benefits. So diversity-based AA rewards the laggards and penalizes the successful. Okay, it's just completely upside down. And today, the main beneficiaries of AA, besides blacks, are Hispanics, a large and growing group, because, in fact, they are falling behind whites and Asians educationally in test scores and other measures. And this has been documented. I refer you to an essay by Jason Richwine in Academic Questions. There are other places where you can find this data. Third, diversity in service of pedagogical goals has no built-in time limits. It could well continue in perpetuity. In oft-quoted passage in her majority opinion in the Grutter case, Justice O'Connor famously stated that she expected that affirmative action would no longer be needed after 25 years. That's now, folks. Her prediction has proven wrong. 25 years later, affirmative action is still going strong, as are the gaps that made it necessary, and they show no sign of abating. And a moment's reflection shows that the logic of O'Connor's prediction is dubious on its face. If the reason for affirmative action is to achieve the benefits of diversity, not to provide remediation, why would we expect it to help close the educational gaps that made it necessary? And why would we think that it ever would bring blacks up to speed so they could compete in a colorblind way? Underachievement could well continue, and it has. Fourth, and perhaps most ominously, AA as a tool for ensuring student diversity has actually undermined its originally stated and hoped for objectives, right? What did Justice Powell say about why educational diversity is a good thing? It should help expand students' educational experience, expose them to thoughts and ideas that they would not previously have encountered, hone their ability to consider and understand alternative points of view. But, in fact, the wages of diversity and the whole diversity, inclusion, equity, and multiculturalism business has been exactly the opposite, severely limiting the ideas that can be expressed on campus, even the facts that can be noticed, mentioned, and discussed, and imposing a mindless conformity about a whole host of topics, and especially those touching on identity politics, which today includes almost everything, right? Even areas in which identity politics would appear to be irrelevant, like science, like medicine. Dear old Justice Powell, and he was dear, and I knew him, the author of the diversity idea, would, I think, be appalled at the narrowness of thinking, the conformity of thought that characterizes elite campuses today. Now, finally, in my last 4 minutes, I want to say something about the case now pending against Harvard University, challenging its admissions practices, which has been brought by a consortium of Asian students and applicants. What is the background here? Why has this suit emerged at this time? I think there are a lot of different factors at work. But one is the increasing importance for career and social class of attending a selective college. And also the continuing firm belief in the meritocracy and the outsized success of Asians has prompted them to think, what's an affirmative action for us? And I think the Harvard case is not the only example of that. The efforts to change admission criteria in the New York City exam high schools has also come up against opposition from Asians who will definitely be hurt by those changes, right? Now, the Harvard case is very fact-intensive and complex. So I just want to say a few basic things about it. The allegations in that case are, in fact, fairly simple. The plaintiffs claim that Harvard is engaging in a deliberate policy of keeping the number of Asian students below a certain threshold, lower than about 18%, despite the fact that Asian applications have soared and their credentials are stellar, right? So how does that work? In asserting that there is discrimination based on their race in violation of federal law, the plaintiffs rely on some striking evidence. Underrepresented minority applicants to Harvard have lower test scores and significantly lower scores and grades to get the same chance of admission as Asians and whites. So those numbers are stark. Harvard's own study of its admissions practices, done in response to complaints even before the lawsuit was filed, acknowledges that even when using the criterion that they say they rely on, not just grades, scores, but extracurriculars, athletics, legacies, special talents, Asians are still underrepresented in the admitting class, and blacks and Hispanics are overrepresented. Third, Asians receive lower scores from the Harvard Admissions Office on the fudge factor subjective measures of desirability, such as creativity, warmth, charisma, generosity, humor, social awareness, which the plaintiffs claim are driven by pernicious stereotypes about Asian. And there is some strange and contradictory evidence on this. Even the New York Times magazine, Pravda itself, admits that some of the data is troubling and unexplained. In giving Asians lower ratings on these personal characteristics, Harvard claims that it's just going along with the judgments of teachers and guidance counselors who tend to rate Asians as less interesting and more cookie cutter, but Harvard itself denies indulging those stereotypes, as it must. But this, of course, just begs the question of why they go along with the teacher ratings and the counselor ratings. No adequate answer has really been given. Now, at this point, the case is submitted to the trial court. We're waiting, but in my opinion, the Asian plaintiffs face an uphill battle in this case. Why is that? Well, for the reasons I already gave you, the Supreme Court has effectively handed universities carte blanche, a blank check. They don't really require them to define any endpoints or goals, to measure them, to give evidence. They've been incredibly lax about all of that, right? Secondly, we have to admit it. The Constitution does not incorporate the SATs. It doesn't require colleges to select based on academic merit or to weight credentials the same for every student. And the colleges remind us that it's all case by case, right? Bad grades or lower scores can be made up for by other characteristics. And how do we get behind that and actually show that there is discrimination, okay? At the Supreme Court level, there are other reasons why this is a hard case to win at the lower court level, just because of the latitude that the Supreme Court has given the lower courts on affirmative action. But at the Supreme Court level, it's another matter. The court could reinterpret the relevant law. It could reformulate AA doctrine to make it stricter and tighter, even in dramatic ways, and that might be a function of whether Trump gets another appointment on the court, right? How could the court tighten the standards relevant to affirmative action? I'll give you a couple of options, coming, in fact, from the concurring and dissenting opinions in prior cases. First, the court could follow Justice Kennedy's opinion in Grutter and put far more teeth into the compelling interest standard, demand that colleges define and demonstrate these so-called pedagogical benefits of diversity with hard evidence, something that's not going to be that easy to do because there's evidence that most students don't learn much of anything in college. Yeah. And then there are colleges that practice little, if any, affirmative action, such as Caltech, and how are their students doing? Another alternative is the court could really bite the bullet and revert to a colorblind standard, adopting Chief Justice Roberts' suggestion in the Seattle School District case, which was a K through 12 case, that the way to stop discriminating is to stop discriminating, and that would forbid the use of race even for benign purposes. Apropos of that, there is one key aspect of the Harvard case, a technical legal one, but very important, that has not received enough attention in coverage of the case. Harvard is a private university. It is not an arm of the state. Therefore, it is not covered by the Constitutional Equal Protection Clause. Well, what is the source of law for challenging affirmative action at Harvard? Well, that is Title VI of the Civil Rights Act, which forbids schools receiving federal funds, which Harvard does in abundance, from discriminating on the grounds of race. But here's an interesting fact. To date, all the big Supreme Court AA cases have involved state-run schools, Michigan, Texas, University of California, and have pretty much been decided under constitutional principles. Now, Although something was said about Title VI in Bakke, it was never followed up. And although many lower courts and scholars have just assumed that the standard for private schools is the same as public, that is not at all obvious from the prior AA cases. And at least one justice, a liberal one at that, and that's Justice Stevens in Bakke, has registered his view that Title VI permits universities no race-based action, whether benign or not. In other words, he opined that Title VI is stricter than the Equal Protection Clause because it uses this term grounded in race, which is much more specific than the equal protection of the law's terms. Okay? Now, will the Supreme Court consider adopting Justice Stevens' view in the Harvard case, assuming that the case does make its way up? I don't know, but it is a possibility, and I think that that point is worth emphasizing in the litigation. I certainly would have done that if I were litigating the case. Indeed, whether any of these significant shifts in AA will occur is anyone's guess. We'll all have to stay tuned for further developments. Thank you.
Thank you, Professor Wax. Now we'll hear from Ryan Williams.
Thank you, Carol. And I did want to say thank you, Carol, for agreeing to moderate this panel. Carol's the president here of her local Federalist Society Lawyers chapter and has helped us arrange continuing legal education credit for our lawyers in the room. So I appreciate that very much. We all do. I'd like today to really talk about the larger historical and constitutional picture behind affirmative action and how it fits into what amounts to a whole new way of thinking, really, on the left about human nature, about rights, about justice. I'm going to borrow heavily, as I often do, from a lot of the work over the years from my colleagues at the Claremont Institute, especially R.J. Pistrito, John Marini, and Charles Kessler. But to put it in the terms of an essay of mine from the spring, the affirmative action case at Harvard is of a piece with the larger conflict in American national life. From academia to our institutions of government, from Hollywood to the mainstream media. And that conflict really is America or Americanism versus the ideology of multiculturalism and its identity politics. This conflict is the latest evolution in an old conflict between what are essentially two different constitutions in America. The first is the Founders' Constitution, as amended, most crucially, of course, the so-called slavery amendments, the 13th, 14th, and 15th. That Constitution had a certain anthropology, a political philosophy to it that served as its core, and that you can find outlined at the very least in the Declaration of Independence. The founders thought really that human nature, for political purposes especially, was a constant or even eternal thing. Humankind was capable of reason, but prone to fits of passion. And passion, of course, would act both against short-term and often long-term common good or notions of justice. So the political problem of tyranny really was ever present. And the classical definition of tyranny, of course, is the ruler or the ruling class ruling in its own interest rather than for the common good. That problem of tyranny really could never be eradicated. It could be managed, but it couldn't really be solved. So for the U.S. founders, this meant that just government had to be limited government, and constitutional structure was an important means to that, to the securing of that justice. And justice was, for the founders, broadly speaking, the safety, happiness, and human flourishing secured by the protection of certain natural rights that human beings had that preceded government. Now, this old American Constitution and the political philosophical consensus that was its foundation had a very good run. But there did come up a critique of this old Constitution, the progressive critique, and it attacked the political philosophical roots of this understanding of the old Constitution and its structure, both. This new progressive or living Constitution rejected the premise of an unchanging human nature, embracing instead a human nature that steadily improved over the millennia and thus made politics and political questions an easier business and more easily solved, even permanently. The progressive argument was that man, or a certain class of the right man, of course, had become more rational and less passionate, more capable of ruling other men without the fear of devolution into tyranny. The political problem then was not the limiting of governmental power in service of the securing of rights. The political problem was then how best to empower government in service, or to apply the latest advances in the social and natural sciences, both to manage the distribution of goods and prosperity, and also to continue to elevate man's consciousness and his continued social, political, even his spiritual perfection. This new constitution, the new progressive constitution, which gained philosophical steam during the Gilded Age and made its full national political debut with Woodrow Wilson, has reigned over our national political life for over a century. Its ascent and its institutional march have been punctuated, messy, it's had setbacks, fits and starts, but roughly speaking, the progressive constitution has advanced in three major waves and really has dominated our politics for a century. The first wave was Wilson, as I mentioned. Its hallmarks were really the administrative state that we've come to know and love, and a new kind of plebiscitary presidential leadership and the national followership to match. The second wave came with FDR, who knew, like all good politicians, how to make sure a crisis didn't go to waste. He deepened and expanded Wilson's project of a national administrative power and lawmaking, and very cleverly pitched it not as a repudiation or a break from the founders or their principles, but really as the necessary fulfillment or perfection of that promise. And then the third wave of progressivism, now thanks to FDR's savvy, rebranded as liberalism, came with LBJ, the 60s, and the Great Society. As innovative and audacious as FDR was, modern big government as we know it really only gets going with this third wave. Liberalism here takes on more of its current flavor, with a focus on personal sexual autonomy and liberation. Cultural liberalism is what Charles Kessler has called it. The kids call it wokeness. So this modern liberal constitution has that significant accumulation of power and content, both theoretical and practical, and it's been running full steam for a century. But there was a big institutional change in the 1960s. Professor Wax talked about it, of course, and it brings us to our current topic of affirmative action. And this institutional change was brought on by the very real and prolonged injustice of slavery, and more importantly, its Jim Crow hangover that started with the end of Reconstruction in 1877. Now, coming to terms with and addressing this injustice, especially in its most visible, potent, and offensive symbol, state-sponsored segregation, would imbue this institutional change of the 60s with a nearly salvific quality in our national life. And it would supercharge progressivism's living constitutionalism as well. And the institutional change was, of course, the 1964 Civil Rights Act, which in spirit was meant to be the fulfillment of the long-delayed promise of the Declaration of Independence of equal protection of rights amongst equal citizens, but which in practice, especially through the bureaucracy and the courts, would quickly transform into a vehicle not only for race-based identity politics at the national level, but also, as we all can see around us today, an identity politics as such, or full stop. Now, my colleague, Chris Caldwell, who's a Claremont Review of Books contributing editor and a Claremont Institute senior fellow, has an excellent new book coming out in January called The Age of Entitlement. He lays out really elegantly, provocatively, and very perceptively the case for our new second constitution really being the post-64 Civil Rights Constitution. Chris has a wonderful eye for cultural and sort of pop culture details. I really encourage you to pick up the book. Be out in January. I speak for myself here now. I'll let Chris speak for himself in the book, but I can't recommend it highly enough. Now, affirmative action, the term, comes from Section 706 of the Civil Rights Act, and it's meant as a tool to compel employers of a certain size or institutions to cease intentional discrimination on the basis of skin color. And very importantly, though, and within really 7 years of its passage, the Supreme Court would determine that such discrimination would be a problem and thus legally actionable, even without the intent to discriminate. This meant a shift in focus from volition on the part of individuals, which is an ancient and vital component of legal culpability, to the effects or results of individual or institutional acts, regardless of the reasons for or intent of those acts. In other words, it's a shift from an intentional racism to what would later be called systemic or institutional racism. Now, this civil rights logic has now expanded to all manner of discrete and insular minorities, to borrow a term from what has been called a pregnant footnote in a 1930s case, well beyond the confines of race, and thus well beyond the original and dominating concern of addressing America's legacy of slavery. So the Harvard affirmative action case is merely the latest example of the tension between this new regime of identity-based civil rights and the older regime or constitution of neutral equal protection. Indeed, the civil rights infrastructure, married to the multiculturalist ideology that has been ascendant in the academy for the last 50 years, means that all group identities, whether based in race, sex, or gender, sexual orientation, or any number of categories we have not yet dreamed up, all of these have a claim to new rights, privileges, and entitlements. These entitlements, which were originally and primarily adjudicated through the courts and administrated through the executive branch or the administrative state, have now spread and are unquestionable dogma at the heights of American government and civil society. This new Constitution inflects our interpersonal interactions and policy at the highest levels of media, education, foreign policy, immigration, and in every Fortune 500 C-suite, if not nearly every publicly traded company in the West, not just America. Now, even many on the left, especially the older and slightly less woke left, just good old-fashioned liberals, they see the galloping fanaticism of the leading edge of this movement and the logic of it as a problem. But it's hard to talk about because this new constitution, this new regime, this new way of social and political organization has its roots in the very real injustice of treating black Americans as second-class citizens for too long. The new comprehensive understanding, I think, is well illustrated in what purports to be merely the latest activist evolution of that old black civil rights movement, Black Lives Matter. As Peter Myers just pointed out yesterday in City Journal in their fall issue, I believe, BLM has gotten into the K-12 educational materials business. In Teach for Black Lives, we find the following as described by Professor Myers. Among BLM's 13 principles are various commitments to intersectionality, that is, the focus on overlapping categories of racial, gender, or sexual victimization. BLM dedicates itself to dismantling cisgender privilege, freeing ourselves from the tight grip of heteronormative thinking, and disrupting the Western prescribed nuclear family structure requirement. The starter kit section on teaching young children declares everybody has the right to choose their own gender by listening to their own heart and mind. Everybody gets to choose if they are a girl or a boy or both or neither or something else, and no one else gets to choose for them. And so again, we should see the Harvard affirmative action case as a data entry in this much larger drama. It's a battle in a much larger war for the soul of America and the soul of American constitutionalism. Now let me end with a provocation. I've left one identity out, the identity that dare not speak its name. White identity, or more specifically, straight white male identity. I know that one pretty well. It's from personal experience. It gets the short end of the identity politics stick, although as Lee will point out, it's not just confined to whites. A leading scholar of identity, demographics, and populism in the West, Eric Kaufman, has described this as asymmetrical multiculturalism. Professor Wax has called it revenge or adversary multiculturalism. And it means, in the words of Dr. Kaufman, multiculturalism for me, but not for thee. With the thee here being heterosexual, or in multiculti speak, cisgender, white males. So perversely, while we have as the original impetus of our new Constitution the desire to place equal individual citizens on an equal footing before the law, what we have gotten, in fact, is a new caste-based civil rights regime with the former oppressor class cast down to the bottom rung of the hierarchy. If we don't arrest and reverse this trend, we will continue to balkanize along expanding lines of group identity. We'll continue to do the opposite of our national motto, as imperfectly as we've always lived up to it, making many identity groups out of what must be one citizenry in a certain fundamental sense, rather than e pluribus unum. This is a recipe for turmoil, for racial demagoguery, for civil war, and for the collapse of domestic tranquility. The proponents of this civically virulent identity politics are playing with fire. And finally, just to conclude, to the extent that this new regime allocates privilege, resources, and opportunities by this new case system, which it most certainly does, it is just a return to the logic of the old slaveocracy. but in a much more antiseptic, managerial, technocratic, and diffuse form. The motto of that old tyrannical regime was pithily described by Abraham Lincoln: "You work, I eat." So much for the progress of progressivism.
Thank you, President Williams. Next, we'll hear from Lee Cheng, and I would like to amend my introduction to Mr. Cheng. Somehow.
Anything you want.
Okay. He is also the director of the Asian American Legal Foundation, and he is a graduate of Harvard University and UC Berkeley Law School, so I neglected to put that on his intro. So with that, carry on.
Thank you very much, Carol. And thank you to the Claremont Institute for having me. I'm glad that my personality was judged sufficiently effervescent. Admitted to this panel. That's, of course, Harvard's standard, but I passed that one too. I'd like to. So first of all, I am very, very deeply honored and grateful for this opportunity to be on the same panel as Professor Wax and also with Ryan. I want to first, start my talk with describing to you how I got involved in fighting ideological multiculturalism, of which affirmative action, which I call racial preference. I like to really focus, when I talk about what we're fighting against, what we're not fighting against is anything affirmative in the least. Much better. What we're not fighting is anything affirmative in the least when we're fighting racial preference. When we use and adopt phrases like affirmative action and diversity, right? We're basically falling into the trap that the extreme progressive left have set for us when they decided to go out and capture language and impose their definitions on us. There's really, again, nothing diverse about what they want to do in the way of diversity. There's nothing affirmative in what they want to do in the way of affirmative action. So I first started, so just by way of background, my parents are immigrants, and they and their parents fled the horrors of collectivism and communism in China in the late 1940s. And they emigrated here to America in the 1960s, after Chinese people were allowed to emigrate to America again. But, they made very good lives for themselves. They went to graduate school here. My father became a librarian, and my mother became a bookkeeper, and we settled in sort of the capital of progressivism in America for many years, which is San Francisco, and that's where I grew up. So in 1984, that's when I first became aware, personally, on a very personal level, that what I'd been taught in civics classes for many years, what I'd read in history books about America being the land where the laws of the land protected everybody equally regardless of race, where that just really wasn't true. And it was kind of shocking that it happened in San Francisco in a public school system. I was applying for a magnet high school in San Francisco called Lowell High School. It's the oldest public high school in the country. A lot of fairly distinguished alumni, including Justice Breyer. And the school required for admission a standardized test score and a review of GPA. Very, very similar to schools in Boston and the specialized schools in New York City. So very proudly, very openly, San Francisco, because the school district wanted to be on the leading edge of progressivism, adopted a quota system, essentially. They called it, I think it was technically under a desegregation consent decree, but they adopted an admissions system where they arbitrarily classified all the school children into 9 different ethnic groups. And Chinese was one, Japanese was one, Korean was one, but if you were specifically Chinese, you had to get a higher score than anybody else. Out of 69 points, you had to get a 65, which really translated to straight A's and a perfect test score. And if you were white or any other Asian, even other Asians, you only needed to get a 61, basically about a B average. And if you were black or Hispanic, you technically really, you needed a 55, but you really didn't need any standards to get in. And I remember thinking about this as a 14-year-old, and I was thinking, how can this be? How can this comport with what I'd been told about equal protection of the laws and about America, right? And I asked a couple of questions and nobody gave me any satisfactory answers. They said, oh, there are some Harvard experts who said that racial mixing is required for black kids to learn. That's why we're imposing caps on how many kids of any ethnic group can be in various schools and classes. And it just never made sense to me. So I kept thinking about this over the years, and there was nothing I can do about it as a teenager. I got to Harvard. I squeaked in. And they had differential, it was well known. They had differential standards at Harvard, at Berkeley at that time as well. Nobody challenged any of these admissions programs legally. They had a very interesting way of making sure lawsuits. There were a few claims filed in lawsuits, I think claims mostly, filed in the 80s against UC Berkeley. They had a really neat way of making them go away. They would just admit the student, and then the case mooted like it did in Defunis v. Odegaard. So when I was at Harvard, I actually did some research about these types of lawsuits, the jurisprudence in the area, and I looked at Bakke, and then I looked at Defunis, and a light bulb kind of went off, and I started also realizing that Asian Americans actually had a very unique role to play in reestablishing balance and parity in equal protection jurisprudence because, well, we're kind of not white, we're kind of not black, and if, in a lot of these programs were being negatively applied and impacted most Asian Americans in academia, and that was, really the sort of the leading edge of where these programs were hitting hard, and that's certainly what I noticed. And I realized also, I started thinking about the right vehicles and mechanisms. The individual lawsuits were not going to work. It was very obvious in Defunis that individual plaintiffs could just be bought off. So after I graduated from Harvard, I took a year off between law school and undergrad to help organize a lawsuit in San Francisco, and it was filed against the San Francisco Unified School District. It was called Ho versus SWSD, and we challenged the desegregation quarter. We challenged the quotas using the vehicle of a class action, right? So we managed to avoid being mooted out, but the problem is class actions take forever. So it took us 6 years, and on the steps of the courthouse when trial was about to start, the national NAACP basically exerted political pressure. They knew they had a loser, complete loser on their hands, and they pressured the SFUSD in the state of California to basically give us everything that we wanted. The quotas went away within a couple of years, and our lawyers got $1.2 million, and they were very happy. And that was the biggest mistake in my legal career, helping to sign off on that settlement, because we had a fact pattern that would have precluded disastrous Supreme Court decisions, I think. That came in subsequent. We had a fact pattern that could have precluded, I think, disastrous Supreme Court decisions that were issued, especially the Grutter decision in 2003, because it's just hard for me to imagine with a fact pattern where the victims were poor Chinese kids that the Supreme Court would have concluded the way they did. So that's where I got started in this fight. So over the years, I've developed certain views, very similar, I think, to what Ryan, articulated, and also Professor Wax, about how racial preference, and how racial preference, the fight against racial preference fits within the context of, constitutional law and equal protection jurisprudence and legislation over the years. And I am not a legal scholar as nearly as distinguished as Professor Wax. This is just my own personal view. But it starts off, of course, with the Constitution, which was somewhat imperfect, which was imperfect, but aspirationally, I think there was an ideal that we were all shooting towards. Dred Scott was obviously a low point, right, where, non-white people were essentially declared, legitimately property. But the 13th and 14th Amendments and the bloodshed of the Civil War, I think, was certainly a very redemptive development. And then we had hiccups. We had some hiccups, like Plessy v. Ferguson, that took us backward. And then we had legislation like the Chinese Exclusion Act, and of course Korematsu during the course of World War II, where I would actually add, sort of the recent sort of deference that the Supreme Court has adopted towards bureaucrats, towards military leaders. That was exactly what was used to justify interning Japanese Americans in World War II. It was deference to military leaders, the same military leaders, or same type of military leaders who subsequently filed an amicus brief in Grutter that the justices relied on to issue the Grutter decision. the pinnacle of civil rights laws jurisprudence was, of course, between the 50s and 60s with Brown versus Board and the Civil Rights Act of 1964. And that was really the beacon, the lighthouse on the shining hill that we'd finally reached. And we aspire to, I think, restore to Americans today. And people started to erode. I think, hopefully, and I hope, largely with good intentions, the progress that had been made, because they were impatient. To some degree, they were impatient with progress, with a slow pace of progress. And then I think, as I've looked at the issue over the years, the other reason was because some people just wanted to grab power a little bit faster. Power, wealth, and money and opportunity a little bit faster. But Supreme Court in I can't remember the exact year, but basically 1974, Bakke?
78.
78. Okay, so the Supreme Court issued the Bakke decision, and it kind of left us, it allowed the path to develop the way it has. In subsequent years, there were pluses and minuses in terms of the decisions issued by the courts. But a real nadir was reached, in my opinion, with the Grutter decision, and I don't think a lot of people are even looking at it as the disaster that it is. For the first time, I think the Supreme Court endorsed a view that could be potentially interpreted as a view that different treatment of individuals can constitute equal treatment of individuals. And I think in subsequent years, there have been efforts, depending on the constitution of the court, in the Jefferson City, Seattle case, to kind of pull back the disaster of the Grutter decision, but we also just lost a big one in Fisher and Fisher 2. So where are we right now? I think certainly I'm very, very heartened, right, to see the Harvard case actually filed. I'm heartened to see the fact that in 2016, much to my surprise, we elected President Trump, and he's been able to appoint 2 Supreme Court justices. I was in great fear about what the Supreme Court would look like if Hillary Clinton had won election in 2016. In fact, quite literally, I was starting to talk to my wife about making plans to leave the country, because and I would have done it, unlike all those people who said they were going to go to Canada. But, and I'll explain why I had such a pessimistic view. But he's appointed 2 Supreme Court justices so far. We may have a third. And the Harvard case finally got filed. We've been talking about taking a case at a university level for many years with a lot of different people. And it never made sense to me why nobody had ever approached Asian American plaintiffs or tried to pull together a class of Asian American plaintiffs to file such a lawsuit, because it's a very compelling story, right? You can't sort of point to, like in Jefferson County, you can't point to the fact that Jefferson County in Kentucky was one of the places where segregation was the worst, and the answer back for many years was very idealistic. The answer back was, we don't think the race of the plaintiff, the parties being discriminated against, should make a difference, but it does, and. So finally, SFFA, Ed Blum, God bless him, pulled together the lawsuit against Harvard. They're also filing a simultaneous suit against UNC at this point. It's a long overdue challenge. What was revealed was nothing surprising. We knew this all along. In 1994, I had access to Harvard admissions data of Harvard students to graduate schools across the country, law schools and medical schools. It showed a really massive amount of divide and differential treatment based on race. But the lawsuit publicly exposed many of these facts. And, and even many progressives who are honest progressives, they can no longer deny that race preference exists and is egregiously used at many of the leading educational institutions in the country. Like Ryan, I think Ryan alluded to the fact that he wasn't sure exactly what the Harvard case what the outcome of the Harvard case would be, whether it be in Professor Wax as well. My own sense is that it's really not going to have a lot of legal significance. I think we have a trial court judge, and I've been predicting this since last October. They have a huge amount of discretion, and she's just been sitting on a decision now for 7 to 8 months. They have almost an unlimited amount of. Why is she doing this? I think part of it is because strategically it's very obvious she was very sympathetic to the defendants, and she prohibited the plaintiffs from really challenging the basic premises behind racial preference, use of racial preference. But she's doing this, I think, part of it is she's trying to outlast the president. So she's trying to outlast President Trump. And she doesn't want a decision to reach the Supreme Court, if it reaches the Supreme Court, until the Trump presidency is over. And at the least, she'll be able to have the benefit of a Solicitor General who will argue in favor of Harvard. But I also think that she is very likely to issue a very narrow ruling that will either seriously preclude or impair the ability to appeal this case up to a higher court to set a broader precedent. And she could very easily find on narrow tailoring grounds that Harvard did something bad, but she will not prohibit Harvard from largely setting the educational admissions policies that it wants. So I think it's wonderful that the case has exposed what's being done. It's raised a profile of the issue to the American public, but I think there's a long war ahead in order that if we want to eliminate racial preferences. So many other things that this lawsuit's exposed, right? I mean, one of the other things that, I think it's also been alluded to are that the beneficiaries of these lawsuits are not the purported victims of slavery or segregation. These programs, race-focused programs, benefit the wealthy of the preferred classes. They do not help the poor or the middle class of the non-preferred classes. The burdens are overwhelmingly borne by the poor in the middle class of the non-preferred classes, i.e. poor whites and Asians. So I think that the statistics are all publicly available. So why do I oppose racial preference? Is it because I am Asian American? That is partially true. I was subject to racial classification. I was forced to be subjected to different unfair standards in several levels of my educational career. But you know what? Hey, I got in, right? I got into Lowell, I got into Harvard, I got into Berkeley. After going to those institutions, I honestly don't care if my kids go to those schools. I don't think I don't think the education offered at Harvard's all that great or Berkeley's all that great. But they should have a choice if they want to go. They should have the same chance. I also, a lot of non-white Americans, right? We could have tremendous professional opportunity, frankly, if we endorsed the current politically correct view of race relations and racial preferences. There are corporations that won't hire people unless you buy into multiculturalism and the expansion of diversity. There are companies now that are telling law firms that every single one of their teams has to look a certain way. They're even requiring the law firms to give credit to people who had absolutely nothing to do with bringing the client in order to hire. These are large Fortune 500, Fortune 100 companies. So there are professional opportunities that I've given up because I don't really want to be woke. But I oppose racial preferences. I continue to oppose racial preferences, and I speak out on them. I have had many friends tell me, don't be so outspokenly. You're going to lose it. The headhunters won't talk to you. That's okay. I'll live with that. But I oppose them because I have 3 kids. They're 12, they're 14, and they're 4. And I want them to grow up in an America where their skin color and their national origin aren't going to be used to punish them or oppress them. Mostly, I've always felt that this is just the right thing to do. I've been compelled to do it since I first became aware of this issue. It's my contribution. I think in the others who are similarly situated is our contribution to the continuation of one of the core ideals of America, that we're all individuals. We should be treated equally under the law. And I'd like as many people as possible to be able to benefit from these ideals. Until, of course, Hillary Clinton gets elected. So.
All right. Thank you, Lee. Now we have time to entertain your questions. If any of you have a question, I believe we have people that might be circulating a mic, although I don't see anyone right now. Perhaps we could pass around a mic. Let's see. Well,
Oh, John's got one. Yeah.
there you go. All right.
Thank you, John. This is why we pay the big bucks.
Yeah.
Thank you. How much impact are studies like Richard Sanders' mismatch theory having on litigation or the dialogue that's currently going on? I didn't hear any discussion of that. I'm very interested because the theory says that basically affirmative action is hurting even the targeted minorities in terms of their ability to compete at these schools.
Mm-hmm. Well, I mean, there's a major industry involved in discrediting Richard Sanders' data, denying it, suppressing it, or just ignoring it. I think it's had virtually zero effect, frankly, on the actual practice of affirmative action and the legal bona fides of affirmative action. And I think that ties into a broader theme here that's extremely important, which is the academic industrial complex is arrogant, impregnable, self-reproducing, and self-perpetuating. And they feel completely invulnerable. They have not altered their practice one iota. And everybody says, well, that's just a theory. Undeniably, this is good for minorities, good for the nation. Everything's fine. They'll deny the fact outright that affirmative action beneficiaries are struggling or doing poorly or less well. They're not really doing poorly. They're just sort of doing less well, and they're continuously being overplaced, as well as doing less well than they would if they were well matched to their institutions. Maybe in law it doesn't matter as much, although I think it does matter, frankly. But in areas like medicine, it's be very afraid. I mean, there is virtually no overlap in the MCATs of blacks and, you know, whites and Asians who get into med school. The numbers, you really have to dig to find them, but they're very concerning.
Well, even more alarmingly, Professor Wax, I think the solution that they would propose to the negative impact of overplacement is that you simply expand the programs, you know, further and further and further.
Critical
right? So
mass.
That's right. Well, so they'll expand it from, you know, high schools to colleges to graduate schools, and then they want to lower the bars on, lower the standards for professional exams. There have been efforts to basically, increase the passage rates or make bar exams easier, and other licensing efforts easier. There are requirements now for hiring, right? In even private companies, there's a lot of pressure to do that. So they're basically going to try to force the imposition of quotas across society in what is really, at the end of the day, I think Ryan's analysis touched on it. I mean, they want to essentially redistribute opportunities and wealth in America.
Yeah, it's a full frontal assault on the meritocracy. That's the bottom line.
It works just fine in America, but Russia doesn't work that way, nor does China.
Do we have another question? Gentleman back.
Over here, but I did want to pick up on something that Professor Wax said. The academy is impregnable, but self-reproducing. So I guess we'll deal with that on the afternoon panel.
And what gender is it?
Unfortunate terminology.
An abortion joke before noon, John? Shame on you.
Yeah, hi, Mike Alexander. I'm trying to understand our objections as conservatives and constitutionalists. And is your objection to the Harvard affirmative action policy, or whatever it is it principally moral? That is, that such discriminations are inherently invidious, or is it constitutional? Both. And bear in mind, as we have this discussion, that we have many laudable institutions who discriminate systematically on the basis of race, religion, and not gender, but sex. We have convents who admit only women, seminaries who admit only Catholic men, and we have wonderful colleges that give special preference to blacks, colleges with great history. So what is it that is bothering us, and how do we articulate our objections to it?
That's a very, very good question. There are two separate questions that I've kind of conflated. One is the legalities of affirmative action, and I think the Equal Protection Clause is more ambiguous than many people think. It doesn't, for example, enshrine the meritocracy. I mean, we don't necessarily have to, even pay any attention to the SATs. So I think there is ambiguity there, genuine ambiguity there. I think there's much less ambiguity for Title VI, believe it or not. Not many people agree with me, but I think the case against Harvard and private universities is paradoxically a easier one for saying that the civil rights laws really are colorblind, that the terminology of the civil rights laws really is colorblind. Now, having left what I think are the difficult legal issues, most of my objections to affirmative action are actually practical and pragmatic. And there, I think conservative principles really do matter. I think what affirmative action gets us into is it gets us into falsehoods, dishonesty, a lack of candor about the reality of human existence, which is really twofold, and I can think of more. One is we are all equal politically, but we are not equal in other ways. And the government is not the guarantor of equality of results. If the government becomes the guarantor of equality of results, tyranny will take over, right? So it is antithetical to small government, which is a fundamental principle of conservatism, right? Of individual responsibility, individual autonomy, and agency, and self-determination. It is absolutely antithetical to those principles to get the government involved in the social engineering of making results equal, right? And first of all, the government, it's a futile quest, right? So that would be my sort of short take on what the problem with affirmative action is.
Yeah, right.
Go ahead.
I'd like to just observe, at least my own view is this, that while equal protection does not mandate meritocracy, I think my sense is that the prohibition against irrational types of discrimination that underlies this type of jurisprudence and also legislation, it's what enables meritocracy, right? So, not discriminating based on race is what will allow us to take advantage of the very best and brightest from around the world, in our own country, who come up. And so my own objection, I'll be completely honest, it's moral, right? I experienced a very visceral sense of inequity when I was told that, because of my background, I had to score higher than kids of other ethnic groups. And, it's based upon the belief that everybody should have the same opportunity, and they can differentiate themselves by what they can do themselves and are willing to do. And then as I study the issue, I firmly believe that we're on solid ground as far as the law right now.
Yeah, you raise a good point, Mike. It's certainly much easier with the old standard of civil rights laws, even predating 64, going back to the late 19th century, which is state action, right? So easier with Berkeley, much harder with Harvard. Although given the fact that our Ivy Leagues are seminaries of anti-Americanism, if we can use this as a cudgel to remove their federal funding, they can discriminate all they want if they quit taking all this money. So that's just kind of a prudential part of it. And then, of course, I mean, in a way, inequality of result is at the heart of American justice as the founders understood it. I mean, the language from the Federalist Papers is one of the first objects of government is the equal protection of unequal faculties. And, unequal faculties are, especially if you happen to be cursed with lesser faculties than many of your fellow citizens or fellow human beings, I mean, it makes life much more difficult, but it's a fact of human nature that we can't get rid of. And so I think any regime of equal protection ought to pare back, I think the spirit of your question ought to pare back the reach of the federal government into institutions. And I mean, it's employers over 50 employees, right? That's the Civil Rights Act of 64 standard. I think we ought to have a candid conversation about whether that was to the extent to that which was really a fundamental overturning of the old Constitution, and whether we think it's a good thing. I think after the accumulation of 70 years of practice and the playing out of that regime by the courts and by the administrative state, and now increasingly by the elites throughout society, we need to revisit that. So, but as I said, it's a very difficult conversation to have.
Yes, the gentleman back there, and then we'll come up here.
Any comments on equal protection of ideology?
Yeah, I'm against it. Let me explain that. I think it's in vogue on the right today to say that really all we need on campus is free speech, absolute free speech. Of course, that betrays the foundation of higher education stretching back to the Middle Ages. But in a more American context, we tolerate a lot of diversity of views in America because we're a tolerant place. But to the extent that, say, an ideology, the older example was Nazis and Skokie, but a newer example would be Islamists. To the extent that an ideology is dedicated to the overthrow of the regime, I don't think the first rule of natural right, according to Locke, is self-preservation. I think that extends to a societal scale as well. So I think we can deduce from that certain ideologies that we ought not to allow in the public square, and even ought not to allow on campuses. Now, I realize that as a prudential matter, given where the campus is today and who controls it, that might not be the best position. Maybe free speech absolutism is the best we can do for the foreseeable future, but we ought to think clearly about it. It's not a principle in any kind of healthy republic that ought to reign forever.
Yeah, can I say, there's no getting away from ideology. Ideology is everywhere. It just needs to be the right ideology. So, I think in academic institutions, which are a subsector of society, they're not all of society, we have this Enlightenment ethos, which is that it's very important to have open debate based on rigor and logic and empiricism, an even-handed institution that allows the truth to emerge. Well, that's an ideology. That's a Enlightenment ideology, yes, but I think it's one that I consider positive and important and responsible in large measure for the success of our society, right? Its prosperity, its technological prowess, its value. So, yeah, ideology is very hard to get away from, but we need to think hard about the ideologies that we are adopting. I think the ideology on campus today is pernicious, and it will destroy us.
There are legal limitations already on free speech, right? You just apply the same principles, right? If you call for destruction of, the country, if you call for murder of individuals, right, you shouldn't be allowed to stand in the public square.
Yeah.
We have another question up here.
But if you wear a MAGA hat, it should be okay.
I'm a businessman, and for my entire career, I've never worked at a firm that wasn't traded on the New York Stock Exchange, so I've always had a preference for big firms. In the last 15 years of my career, I cannot tell you how many meetings and trainings I have been to on diversity and why it should be honored. And not only why it should be honored, but why we are all made better, this mantra that we are all made better by diversity. I read Miss McDonald's last book because of the title. I thought she might say why diversity was supposed to make us better. I've never heard anybody articulate it, and I'm just curious do any of you know of any paper, written, data, anything that says it's true, or is it just a mantra?
Yeah, well, first of all, as with so many of these do-gooder items of faith, there's so much less there than meets the eye. There's a couple of papers, I think it's by, and I'm blanking on the name of the guy who wrote them, Page or some sort like that, where he does some really questionable data crunching or experiments showing that diverse groups or teams come up with better results. It's one of these little labby type experiments that, you know, probably doesn't generalize beyond an inch outside the room where it was conducted. But that is really pretty much all of it. And what is ignored every single day of the week, of course, is all the evidence that uniform and homogeneous societies and groups and teams do great things. I mean, if you've seen the Apollo 11 film and look at the control room, okay, it's a bunch of white guys, right, with pocket protectors. They took us to the moon. You know, the Germans and the French in the 17th and 18th and 19th centuries, the Brits, I mean, these were not diverse societies. They had a few people from outside, you know, that would definitely happen, but they were incredibly uniform societies that shared values, shared understandings, shared cultural precepts and customs and practices, and they produced great things. Well, you know, if you say stuff like that in the academy, you're labeled repugnant, a hater, contrary to our institutional values, which is the latest thing, right? As Glenn Lowry says, that's creepy. That assumes agreement when there isn't any. So all the counter evidence is just completely ignored. In other words, what I'm saying is this is made up stuff. Right? It's just made up stuff. Sometimes diversity is good, sometimes it's not. There's no uniform rule about it. It depends.
The closest I've seen, so I asked exactly this question last week to a friend of mine, a liberal friend of mine, and he said to me, I'm not going to send you any studies, I just know that heterogeneity, he literally said, I can show you the Facebook, post, and he just said, I just know that heterogeneity in groups results in better solutions. I know from my personal experience, but I've seen these studies. Essentially, they confirmed his bias. But, the closest that I have seen over the course of many years to a study that supposedly numerically demonstrates the superiority in terms of business outcome, because that's what's driving a lot of the stuff in Fortune 1000 companies and big companies now. The closest I've seen is a study that says that large companies with 3 or more women on their boards of directors have stock prices that perform better. That's the closest I've ever seen, right? And leaving aside the question of like, well, did they have 3 women on their boards when they got to become large? Nobody questions these. They don't question these studies. They seize upon every opportunity to put this headline up that companies with more female board members will have higher stock prices, right? And essentially, like at this point, I mean, very candidly, it's become a money and power grab, right? By the people who are at the pinnacles of the groups that seek to be preferred, right? Rich women, white, mostly Asian women, are getting appointed to boards because boards are saying the next 4 seats are all going to be female or minority. And, that's really what I've seen in the way of real studies.
Yeah, it's a spoil system. And let me say one more thing. Nobody in any sociology department in any top university ever got ahead by taking one of these studies and debunking them, right? Never. That's not how you get promoted. That's not how you get tenure. Take my word for it.
There's the, there's the self-interest aspect, which I think is perfectly valid. But I think the best way to understand diversity as our strength is as a theological catechism, not an empirical claim.
Yeah. Look at the reaction when you question it, right?
Lots of hands.
This gentleman up here in the pink shirt and blue.
In 1776, or thereabouts, some people had the crazy idea that the average man can rule himself. That was utterly nuts. Well, as a matter of fact, he can. And my big objection to what is going on here is, number one, it's a denial of merit or perceived merit, a big war against that. But the other situation is this. I believe the average man, that's our public out in the American society, can rule himself if he gets the right information. if the media is unbiased.
Sorry.
And I think that's our problem. What is the media doing? The whole American experiment is that the average man can do damn well if you leave him alone and he gets the right information. He's not stupid, in spite of what the elitists like to say. He'll figure it out, he or she. So anyway, I have a problem with the media. And, and how it got that way, it's like they're not particularly interested in the truth or objective reality. It's something they just ban. It's all ideology. And that's my comment.
Okay. Do
Can
we
I
have
just-
another question? Oh, go ahead.
I just say something about the media and also about ruling yourself. So, I'm not that much of a libertarian. I think people, as opposed to the government ruling you and you ruling yourself, I definitely vote for the latter. But I think when people rule themselves, they do need a strong civil society, positive norms and institutions to support their good choices. So the difference between liberty and license is one that goes way back to 1776 and before, and I think it's still viable. And we have now equated liberty and license, I'm afraid, or the ruling class has, enshrined, let's say, sexual liberation as the highest good and other similar liberations, and that's part of the problem. But the media has been captured by a bunch of 20 and 30-something callow, ignorant, self-regarding, preening Harvard graduates. I mean, you would not believe. I hate to be so,
Thankfully,
So
that's after my
blunt.
time. That's after my time. So.
It would shock you, who is running places like the New York Times and why they don't even make a pretense now of being nonpartisan. They've just given up on it. And so be very wary. Do not believe what you read. It's all tainted by this partisanship. And it goes back to the fact that at these institutions, which are very sought after because they are the gateways to the upper middle class and to good jobs, an ideology is being pushed relentlessly. And if you dissent from that ideology, you will regret it. Okay, I can attest to that myself. I have tenure, so I'm protected. But if you were to ask the president of my university point blank, and she were honest, and that's a big if, would Amy Wax still be teaching here if she didn't have tenure? The only plausible answer is no.
So if the Harvard case is not going to solve this problem, what is?
Decades of litigation, right? I mean, people look at Brown versus Board and they think it's Thurgood Marshall standing at the steps of the Supreme Court, right? In victory. And it was 3-4 decades of litigation, of very thoughtful, strategic litigation, finding the right plaintiffs, raising a pile of money, finding allies, blah, blah, blah. This is the opening skirmish if the Republic's going to survive. And if it doesn't, then I'm out of here, so.
Did you have a...
Not Canada.
Yeah.
Suspenders, yeah.
So I was impressed with Professor Wax's distillation of the justification of affirmative action, starting out with reparations and then moving to diversity, and now it's just become really, as you said, overturning the meritocracy and the principles of meritocracy. And so my question for all of you is, do you think that the kind of the architects, I realize the foot soldiers are just going along talking about diversity and so forth, but the architects of this drive, do you think they really, they're really at heart just egalitarians, just trying to overturn society and push the egalitarian ideals that they've just pushed forever, and it's just being repackaged in the name of diversity and affirmative action?
Well, I mean, you're asking me, what is it like to be a bat? I mean, I have no idea how these people think. It's very, very hard for me to put myself into their... It's like hard for me to understand people who throw litter on the ground, They're almost like another species. I would only note that there is a huge amount of hypocrisy and limousine liberalism going on here. The more adamantly someone advocates for diversity and the more sanctimoniously, I always look up the zip code where they live. Right? I just did that the other day to someone who lives in Wayland, Massachusetts. All right? 89% white, 9% Asian, 0.5% black. And I said, if diversity is so great, why do you live in Wayland? You know, the meritocracy. The meritocracy is just a blind for privilege, white privilege. It's a nefarious way to perpetuate the power structure, blah, blah, blah. But my kid, you know, is going to SAT prep and they got a 780 and, you know, they just got into Harvard. So this stuff, it just doesn't compute. There's a discrepancy here between what people say and what they actually do. I noticed this as a sociological and anthropological feature, and I don't know what more to say about it, you know. I will claim the virtue of consistency. That's all.
We may not relate, though, Professor Wax, but I think history can inform us what's driving the people. I mean, I think on the one hand, you could potentially follow the money, where the money's coming from, and looking at what, say, a Tom Steyer wants, right? And then on the other hand, you can also look at who is really serving as the ideological, right, foundation, providing the ideological foundation for what's going on. And when you look at history, history often had these revolutionary movements that started with people who use sweet-sounding words. And at the end of the day, they want power for themselves. They want wealth for themselves. Look in modern history, look at Chavez, look at Maduro, look at Mugabe, you know, who just died, thank God. Right, you know, and just look at them. They all started off the same way, saying that they wanted to, you know, help the little people. Look at Castro, look at Mao, look at all those turds.
Just curious, the educational landscape is at the same time very competitive, and there are a number of higher educational institutions that do seem to be focused on a meritocracy. And Ryan, given your background, Hillsdale seems to be one of them. So I'm just curious, notwithstanding what's going on at a lot of universities and their affirmative action programs, can we not point to many other colleges and universities that continue to operate on a meritocracy, and aren't their stars rising?
Some of them, yeah. Hillsdale's a paradigmatic example. I mean, I started there in 2000, which is when Larry Arnn started there. He went from the Claremont Institute to run Hillsdale. He's raised $1.3 billion since then, I think. Their endowment was $40 million. It's now over 700, I think. But look, they're gearing up for coming battles, and I think it has a lot to do with, to the extent that places like Hillsdale and others become a bastion of colorblind meritocracy, and frankly continue to practice more or less the principles of Judeo-Christian morality and natural law, et cetera, and the way they conduct themselves day to day, especially with the rise of sexual identity politics. The feds are going to come after them soon, and they're all preparing for it. So that will be a good fight. It will be an occasion to, I think, educate the public about this sort of thing. But as far as I'm concerned, I think conservatives, and this is partly due to the influence of libertarians, are not thinking creatively enough about what to do about the problem of higher ed. And starting with the Ivies and going down the top 20 liberal arts colleges, with a few exceptions, we ought to be thinking creatively about how to defund them, discredit them, and take an axe to them, frankly. Doesn't mean, you know, you pass some federal law to kill Harvard, but I...
Very creative.
You know, you... But we need to think creatively about this, and I think, you know, the place to start would be with the huge subsidies they get from us.
Yeah.
And the documentation is a way to start. I mean, people, the normal public, it will take a president, and I don't think this one of Trump's vices, I think, is he's a little overawed by the Ivies. He likes credentials, so he's not the right man to do it. But someone subsequent really should lead a national campaign And some of the work of think tanks can do is to really catalog all this stuff. And people, I mean, the general public would be shocked about, outside of some defense funding and some hard sciences funding, of what's getting funded by the feds, thus by taxpayers at all these Ivies. I mean, it's amazing. You wouldn't believe it.
It's going to be really hard to break the lock of
Yeah.
the prestigious Ivies, but I just finished a first draft of an essay. I don't know if it'll see the light of day. I'm trying to co-author it, called Defund the Ivies. And here's the problem. People don't know. It's a vanity project for a lot of the donors. The public subsidies is one problem. The private subsidies are enormous. They don't know how tiny and how elite the constituency is that gets educated by these selective universities. Over 50% of the four-year colleges in this country take every comer. They aren't selective at all. The number of students going to universities that take less than a quarter of their applicants is tiny. It's in the single digits, and it's mostly upper middle class people. So those numbers need to get out. The other thing is that donors need an alternative. They need other causes to give to, and I think there should be a major campaign to identify charities and philanthropies and projects that benefit ordinary people, the ordinary people of this country, you know, kind of along the lines of America first, what do the deplorables need? And that is not what moneyed upper middle class Ivy graduates are focused on. Right? They need to refocus their money and their efforts, and they need to understand the enormous endowments that these institutions already have. So that's going to be very, very hard to do, but, you know, it's a start to try and publicize. Of course, it all starts with the fact that these institutions are anti-Western. They are replete with anti-American propaganda. They are teaching their students that we are nothing but our crimes, that our gains are all ill-gotten. There's all sorts of horrible lessons that are being learned in these institutions, and that is spawning our future ruling class.
How many people in this room are willing to admit you've donated to an Ivy League college? Raise your hand. Just stop.
Stop.
Yeah, just stop.
Don't ever do it again.
Okay. With that, I believe we are wrapped up, and we will be reconvening at lunch at 12:30 in the Bush Auditorium.
Yeah, so to get to lunch, go down the elevator to the first floor and walk that way, right, Carolyn?
Thank you. Thank
Yeah.
you. Let's
Thanks.
thank our panelists.